Special Counsel Jack Smith has just filed with the United States Supreme Court his response to Donald Trump's application for a stay of proceedings pending a petition for certiorari. This is in the Washington, D.C. federal criminal case where last week the D.C. Circuit Court of Appeals agreed with the lower federal court judge Tanya Chutkan, and the three-judge D.C. Circuit panel rejected Donald Trump's claim of absolute presidential immunity. The D.C. Circuit Court of Appeals gave Donald Trump until February 12th to seek an application for a stay pending the filing of a petition for certiorari with the United States Supreme Court to continue the pause or the stay in the district court proceedings, which was triggered by the fact that Donald Trump filed this appeal on the issue of absolute presidential immunity, which Judge Tanya Chutkan rejected, which the D.C. Circuit rejected. Donald Trump on February 12th filed that application for a stay with the United States Supreme Court. The next day, the United States Supreme Court responded very quickly and gave Special Counsel Jack Smith until next Tuesday, February 20th, to file his response. As we said here on Legal AF on MeidasTouch Network, we said that Jack Smith likely already has his response ready, and that Special Counsel Jack Smith would probably respond in 24 to 48 hours to the United States Supreme Court. That is exactly what Special Counsel Jack Smith did. Let me give you the highlights of Special Counsel Jack Smith's response. First, to be clear, Special Counsel Jack Smith says that the Supreme Court should not grant a stay for Donald Trump. They should reject the application for a stay and send this directly back to the district court so that the proceedings could continue, that the pretrial proceedings could take place, so that Donald Trump can't delay this any longer. So the big headline here, Special Counsel Jack Smith asking the United States Supreme Court reject Donald Trump's application for a stay. The kind of follow-up corollary argument by Special Counsel Jack Smith is, if you are inclined, United States Supreme Court, to grant this application for a stay, just convert Donald Trump's stay application into the petition for certiorari. In other words, into the request that you take up the issue of absolute presidential immunity as an appeal from what the D.C. Circuit Court of Appeals did, and then set an expedited hearing schedule the same way you did with the 14th Amendment Section 3 cases. Let's get the show on the road and we can have oral argument as early as next month so that this trial in Washington, D.C. can take place forthwith, can take place essentially as early as this summer or in the next few months. So Special Counsel Jack Smith is arguing that Donald Trump doesn't satisfy the elements to succeed on an application for a stay. You need 5 justices ultimately to grant an application for a stay. It would take 4 justices to grant a petition for certiorari, in other words, to actually hear the appeal. But Special Counsel Jack Smith says, regarding both, you don't need to hear this on certiorari, and you should not grant the application for a stay. But if you do grant certiorari, then let's just get the show on the road, convert Trump's motion into a petition for certiorari, and let's set oral argument. Let's get our briefings to you on an expedited basis here. So Special Counsel Jack Smith says regarding the application for a stay that Donald Trump doesn't satisfy the elements there. The elements are a likelihood that the Supreme Court would accept the petition for certiorari, and Special Counsel Jack Smith says, look, you've already denied it when we, the Special Counsel's Office, previously requested, so you should just deny it. The D.C. Circuit Court of Appeals ruling is bulletproof, so we don't need you to intervene at this time, Supreme Court. The next element that Donald Trump would have to show for an application for a stay. Trump would have to show that there is a fair prospect that not only would certiorari be granted, but that there would be a reversal of the D.C. Circuit Court of Appeals ruling, where the D.C. Circuit Court of Appeals rejected Donald Trump's claim of absolute presidential immunity. And Special Counsel Jack Smith says there is not a fair prospect of reversal. What the D.C. Circuit Court of Appeals wrote in their opinion is bulletproof. Donald Trump's claim of absolute presidential immunity is frivolous. There is not a fair prospect of success here. And finally, Special Counsel Jack Smith says a balancing of the equities test, which is the other element here that Donald Trump would have to show, that when you balance the equities, it would cause Donald Trump irreparable harm. Special Counsel Jack Smith says no, on the contrary, balancing the equities here shows that there should be a trial and Donald Trump's delay tactics should be rejected. Special Counsel Jack Smith states the following: applicant, referring to Donald Trump, seeks a stay to prevent proceedings in the district court from moving towards trial. Applicant, referring to Donald Trump, cannot show, as he must, to merit a stay, a fair prospect of success in this court, nor can applicant, referring to Donald Trump, show that the balance of equities or the public interest favors continued delay of the criminal proceedings. Special Counsel Jack Smith goes on to say, the charged crimes strike at the heart of our democracy. A president's alleged criminal scheme to overturn an election and thwart the peaceful transfer of power to his successor should be the last place to recognize a novel form of absolute immunity from criminal law. And for Trump to get a stay, he must show that he has a, quote, fair prospect of success in the court. He cannot show this. Just let me go through with you some of Special Counsel Jack Smith's brief so you can read it for yourself. And I wanted to kind of establish what all those terms mean, what this is about, the procedural history, so that when I read this for you and share this with you, it all makes a little bit more sense. So here is response in opposition to application for a stay of the mandate of the United States Court of Appeals for the District of Columbia Circuit. And to be clear, when we're talking about staying a mandate, that basically means when the mandate is sent from a district court, a D.C. Circuit Court of Appeals or a Circuit Court of Appeals back to the district court, it basically means that what's being transmitted is the judgment by the Circuit Court of Appeals, and that's what starts the proceedings again and lifts the stay before the district court. So that's that. Goes on to say, the special counsel, on behalf of the United States, respectfully submits this opposition to the application for a stay of mandate of the Court of Appeals pending the filing and disposition of applicant's forthcoming petition for certiorari. The stay should be denied because of applicants, referring to Trump's, failure to meet this court's settled standards. The application stems from an indictment returned by a grand jury against applicant, a former president of the United States, charging him with federal crimes committed and an alleged effort to perpetuate himself in power and prevent the lawful winner of the 2020 presidential election from taking office. The charged crimes strike at the heart of our democracy. A president's alleged criminal scheme to overturn an election and thwart the peaceful transfer of power to his successor should be the last place to recognize a novel form of absolute immunity from federal criminal law. Applicant, Trump, seeks a stay to prevent proceedings in the district court from moving towards trial, which the district court had scheduled to begin on March 4, 2024, before applicant's interlocutory appeal necessitated postponement of that date. Applicant, Trump, cannot show, as he must, to merit a stay, a fair prospect of success in this court, nor can applicant show that the balance of equities or the public interest favors continued delay of the criminal proceedings. To the contrary, the equities and public interest strongly disfavor a stay. Applicant's interlocutory appeal placed the district court proceedings on hold, thus delaying the trial and verdict in this case. He has no entitlement to a further stay while seeking discretionary review from this court. Delay in the resolution of these charges threatens to frustrate the public interest in a speedy and fair verdict, a compelling interest in every criminal case, and one that has unique national importance here, as it involves federal criminal charges against a former president for alleged criminal efforts to overturn the results of a presidential election, including through the use of official power. Recognizing that applicants' claim of immunity implicates fundamental issues about the role of the president, the government filed a petition for a writ of certiorari before judgment to provide this court with the opportunity to resolve applicants' immunity claims at the earliest possible juncture. The court denied review. Pause there. What Special Counsel Jack Smith is doing there is acknowledging that he previously filed an expedited appeal directly to the United States Supreme Court. So here's Special Counsel Jack Smith saying, look, noting that this dealt with fundamental governmental issues, we did go to you, Supreme Court, a few months back, but you rejected that, and so you denied that review. To the extent that this denial by you, the Supreme Court, to the extent that this denial reflected an inclination not to review applicants' claim of absolute immunity from the federal criminal prosecution, the court should likewise deny this application and any forthcoming petition, especially now that the Court of Appeals has unanimously affirmed the denial of immunity in a thorough opinion that correctly rejects applicants' arguments. So there, Special Counsel Jack Smith saying, look, Supreme Court, I get that we sought expedited appeal from you to skip the D.C. Circuit, but you rejected that. Okay, let bygones be bygones. But the D.C. Circuit Court of Appeals has now ruled. They have a thorough opinion. And now that we have that new data, the new ruling, you don't need to hear this right now, because what the D.C. Circuit Court of Appeals showed why there's no reason at all that you need to hear it. It was thorough. They rejected it. Let's go to trial. If, however, this court believes that applicants' claim, if Trump's claim merits review at this time, the government respectfully requests that it treat the application as a petition for a writ of certiorari, grant the petition, and set the case for an expedited briefing and argument. An expedited schedule would permit the court to issue its opinion and judgment, resolving the threshold immunity issues as promptly as possible this term, so that if the court rejects applicants' immunity claim, a timely and fair trial can begin with minimal additional delay. The government proposes a schedule that would permit argument in March 2024, consistent with the court's expedition of the other cases meriting such treatment. So here, Special Counsel Jack Smith says, and it's fleshed out more on page 36 through 38 of this brief that was submitted by Special Counsel Jack Smith, is, look, if you do want to grant Donald Trump's application for a stay, which you shouldn't, then just treat what Donald Trump filed as a petition for certiorari, accept it, and set a oral argument in March so we could get the show on the road and start our trial, shortly thereafter, when you eventually reject Donald Trump's absolute immunity claims the same way the D.C. Circuit Court of Appeals rejected it. But justices of the Supreme Court, the judges in the D.C. Circuit and the federal judge in the district court, they got it right. There's no need to disturb what they're doing. This is not a time where you need to intervene anymore. Reject the stay. There's no need to hear certiorari. Send this case right back to the district court, and we're going to be ready to get on our way with trial. So again, Special Counsel Jack Smith filing it early, just as we expected. Filed it before it was due on February 20th and covered all of his bases with the issue on, if you grant the stay, here's how we deal with certiorari on an expedited basis. But Jack Smith says, don't grant the stay. Let's get these proceedings going back with the district court in Washington, D.C. So there you have it, folks. I'm Ben Meiselas. This is the MeidasTouch Network. If you like reporting like this and you want to support independent media, go to patreon.com/MeidasTouch and hit subscribe right now here. Let's get to 3 million subscribers together and have a great day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.